Good afternoon, everyone. Welcome to PPA 500 and our last session, our last Zoom session for our short time together. So we have tonight's session, and then we do not have a session scheduled for next Thursday. Next Thursday will just be to afford you time to finish up your final assessment, and that final assessment then will be due no later than midnight next Thursday. So what we'll be doing tonight is just wrapping up the last bit of information that we usually cover in this course. And that last piece of information, again, looks at the functions of public administration and primarily focuses on the two functions of managing human resources and managing fiscal resources. So in our first half of class tonight, we'll talk about managing human resources to get you then ready for your PPA 577 Human Resource Management course. And then the second half of class, we'll talk about managing fiscal resources to get you ready then for PPA 525 Public Budgeting and Finance. Once we finish our material tonight on managing human and managing fiscal resources, that will also wrap up all the material that you need for the final assessment, which will then allow you to answer those remaining scenarios on the final, so you can have the final assessment turned in no later than midnight next Thursday. As we talked about last week for the final assessment, all the same ground rules apply as applied to the midterm assessment. So you have five scenarios, two questions for each of those scenarios. Being as parsimonious as possible, just like you did on the midterm, a paragraph or two will certainly be enough to get the job done adequately for each one of those questions. So that's where we currently are. Hopefully, if everything goes well and all the final assessments come in by midnight next Thursday, I'll spend next Friday working on evaluating them and getting all the final grades taken care of. Then hopefully be able to input your final grades by the weekend, and then hopefully they'll be visible to you then by the following week. And you can then move onward and upward. If you have a second half hybrid course, you can move on to that second half hybrid course. If you don't have a second half hybrid course, then you have a little bit more free time on your hands in the second half of the semester than you've had here in the first half. So we've got a lot to cover tonight. So let me go ahead and jump into it to make sure we get through everything that we need to cover. First half of class, we'll talk management of human resources. So before we get into the actual functions of how we manage human resources, we need to acknowledge the importance of managing human resources. 85 to 90% of our public budgets will be comprised of spending on personnel. So salaries and benefits will take up a large, overwhelming percentage of our public budgets. Since we are spending so much money on managing human resources, we obviously want to make sure we do a very good, very efficient, and very effective job of doing so. Now, as we are managing these human resources are obviously our public administrators. These are the folks who are working in our public organizations. So these are our public administrators, our public bureaucrats. So before we actually get into those functions of how we manage those folks, I think we really should talk about the development of our system of public employment, where we started at in terms of how we hired people to work in the public sector, and then how that evolved into our current system of public employment. So where we started with the founding of the nation back in the 1780s, when we hired people to work in government in the 1780s throughout all the way up until the 1820s or so, we were hiring people based upon who they were. So we were hiring these quote unquote gentlemen in society. So we were hiring people in society who were coming from the quote unquote best social standing. These were people who were coming from well-established families. They were coming from the most prestigious educational institutions. These people were supposed to be the upper crust, the best of the best in society. Hence the reason why they were called gentlemen. And so our first era from the 1780s up until the 1820s was known as the era of gentlemen. The reason why we were hiring these folks based upon who they were is to try and add some legitimacy to the national government. So tomorrow morning we will wake up and we will be relatively certain that the national government will still be there, just like it was today. That was not always an assured. And if you look at the late 1700s, it was a very fledgling national government. A lot of anti-federalists, as we've talked about before in this class, were very worried and very concerned about this new national government. In the early 1800s, we had the War of 1812 after all, and we were invaded by England again, and British troops were burning our capital and burning our buildings. So there was a lot of concern about how long this national government would be around. So we really needed to legitimize this national government in the eyes of the citizens, and that's why we hire people based upon their status in society to add that legitimacy to the national government. Then, as we know from our discussion last week of policymaking, major changes are oftentimes made to public policies as the result of a triggering event. So something happens that galvanizes public opinion around the idea that we need to change our approach. We need to change the way in which we are dealing with this policy. And so the triggering event was the election of 1824. And if you remember back to your American history courses, the election of 1824 was known as the corrupt bargain. Because in the election of 1824, we had multiple candidates who were running for the presidency. The three top candidates were John Quincy Adams, Andrew Jackson, and Henry Clay, the Speaker of the House. And we had other candidates too, but those were your top three candidates. We know from our reading of the Constitution that in order to be elected president, that person must win a majority of the votes in the Electoral College. Well, since you have a multitude of people who are running for the presidency, we know anytime you have multiple people running, it becomes more and more difficult for us to have one candidate get a majority. And that's what happened in the election of 1824. Andrew Jackson won more popular votes than any other candidate. Andrew Jackson also won more electoral votes than any other candidate, but he failed to get to that level of winning a majority of electoral votes. Well, based on our reading of the Constitution, we all know that if a candidate does not get a majority of the votes in the Electoral College, the presidential election is then thrown into the House of Representatives, and the House of Representatives then selects the next president. So the election was thrown into the House of Representatives, and here is where it becomes what's been known as the corrupt bargain. You have this alleged deal, and again, it's alleged because John Quincy Adams and Henry Clay both swore that it was not a deal and that this didn't happen, but you had this alleged agreement, this alleged bargain between John Quincy Adams and Henry Clay, that if Henry Clay would get his supporters in the House to throw their support behind John Quincy Adams, to give John Quincy Adams enough votes to be selected as president in the House, that once John Quincy Adams became president, he would then award Henry Clay with a cabinet position. Now, whenever these presidential elections go into the House of Representatives, it's a strange situation in which every congressional delegation gets one singular vote, regardless of the size of that congressional delegation. So if this would happen in 2028 and the election would get thrown into the House of Representatives, the congressional delegation from the state of Wyoming, we get one vote for president. The congressional delegation from California would also get one singular vote. So each delegation gets one vote, despite the fact that there is only one representative from Wyoming in the House of Representatives, and there are, 53 from the state of California. Each delegation only gets one vote. So what happened is John Quincy Adams then had enough votes in the House to be selected as president. Once he became president, he then nominated Henry Clay to be his Secretary of State. And that, of course, came to be known as the corrupt bargain. Well, that corrupt bargain kind of turned public opinion against this whole idea of this elitist approach. You had an elitist and another elitist who came to this corrupt bargain to essentially, in the eyes of Jackson supporters, steal the presidency away from an average ordinary citizen like Andrew Jackson. So 4 years later in 1828, we had a rematch between President John Quincy Adams and Andrew Jackson. And in 1828, Andrew Jackson won majorities in both the popular as well as the electoral college and won the presidency outright. When Jackson comes into the White House after the election of 1828, he brings with him this belief in the common person. And he believed that the work of government doesn't need to be done by these gentlemen. It doesn't need to be done by these elites, but rather the work of government can and should be done by average, ordinary citizens. And so, by bringing this whole idea of average, ordinary citizens into the public bureaucracy, you kind of have this sea change in our acceptance of who should be our bureaucrats and who should be our public employees. So, Jackson, believing that average, ordinary citizens should serve in government, also was a very big believer in partisanship. And he believed the old adage to the victor go the spoils. And so the winning candidate, the winning political party, should then be able to hand out these jobs in government as rewards to people who help them get elected. And that's what then begins our second era of public employment, known as the era of spoils, sometimes called the era of patronage. So to the victor go the spoils. If you supported the winning candidate, you support the winning political party, then you could expect to then get a position offered to you in government. We read about George Washington Plunkett, or at least we talked about George Washington Plunkett in his memoirs, Plunkett of Tammany Hall, looking at his time in the political machine of Tammany Hall. You not only had an era of spoils at the national level, but you also had that at the state and local level as well. These major political machines were essentially controlling all aspects of governance within their cities. One of the things that George Washington Plunkett talks about in his memoirs is he gives advice to what he calls young men who want to go into a career in government. And his advice to, and because they were young men at the time, his advice to young men was, if you want to get a job in government, do not go to college and fill your head with what he referred to as college rot. Instead of filling your head with college rot, get out on the streets and support candidates. Learn how to round up votes for candidates and help get people elected. That's how you got a job in the era of in the era of spoils, the era of patronage. So now we're not selecting people to work in government based upon who they are. Instead, we're hiring them based upon who they know. Did they support the right candidate? Did they support the winning political party? Well, clearly, when you are bringing people into these jobs in government based upon their ability to get people elected, the skill set it takes to win an election is not always the same skill set it takes to govern effectively. And oftentimes, it's rarely the skill set necessary to effectively govern. So we had a lot of corruption. We had a lot of malfeasance and misfeasance and inefficiency going on during the era of spoils. The gentleman that you see on the screen there is a gentleman by the name of George Pendleton. And George Pendleton was a member of Congress who saw a lot of these inefficiencies and saw a lot of this corruption and wanted to do something about it. And it wasn't just George Pendleton. At the local level, we had a lot of local municipal leagues throughout the 1800s that were working very hard to try and reform local government to replace the era of spoils with more merit-based hiring. But nothing was really happening, especially at the national level, until we got another triggering event that would force public opinion to accept this idea of hiring people based upon merit. And that major triggering event occurred with the assassination of President Garfield. So in the election of 1880, President Garfield wins the presidency. Garfield was not the person that his party thought would get the nomination. And Garfield actually really got the nomination based upon a speech that he gave at the nominating convention. And it was a speech nominating someone else to be a presidential candidate. But his speech was received so well, and the convention was so brokered, it was so divided between candidates that Garfield pretty quickly rose through the ranks at that convention, and not necessarily something he had planned on in 1880, but ended up being nominated by his party for the office of president. The person who a lot of people thought, Roscoe Conklin, they thought he would end up being the presidential nominee, but actually ended up being James Garfield. So Garfield gets the nomination and Garfield gets elected to the presidency. There's a gentleman by the name of Charles J. Guiteau. And if you're interested in this story of how Guiteau assassinates Garfield, there's a great miniseries that came out late last year. I believe it's called Death by Lightning. And if you're really interested, it's a great miniseries. It's dramatized, and so you can't believe everything in it, but it's a pretty good, accurate account of the relationship, if there even was one, between Charles J. Guiteau and James Garfield, and some of the reasons why Guiteau assassinated Garfield. But Charles J. Guiteau was this interesting individual who had a lot of failed careers during his time. He was, at one point in time, he was a preacher. At one point in time, he was an author. He was a would-be soldier. He was a would-be office seeker. He had all these different careers that he wanted to try with very little success. But he had a chance meeting with President Garfield before Garfield was elected, actually at the convention. It was just a simple shaking of the hands and, telling Garfield he admired him. But it really kind of spurred Guiteau into writing some campaign speeches. And he then started to fancy himself a speechwriter. So he wrote some campaign speeches for the Garfield campaign, shared them with the Garfield campaign. There's no evidence whatsoever that James Garfield ever saw any of these speeches. There's no evidence any of these speeches were used by the Garfield campaign. The Garfield campaign actually kind of turned Guiteau away as a not a lunatic, but kind of a strange type of fellow. And so there's no evidence whatsoever that Guiteau contributed whatsoever to the election of Garfield as president. But once Garfield wins the White House, Guiteau felt that he was owed something. This is the era of spoils, after all. And so, in Guiteau's mind, I helped Garfield get elected, so therefore I should be rewarded with a position in the federal government. Clearly, he was not awarded with a position in the federal government. And so Guiteau eventually thought he wanted to be remembered, like most assassins do. He wanted people to remember his name. He wanted to do something important and significant. And so he assassinated President Garfield. But also in his kind of warped thinking, Guiteau also thought that President Garfield's vice president was Chester Arthur. And Chester Arthur was pretty much the polar opposite of James Garfield. James Garfield was working toward bringing merit-based hiring into the civil service. Chester Arthur was very much of a partisan. I won't say a political hack, but essentially Chester Arthur was kind of an enforcer for the local party. And so he was very much a ardent believer in patronage and the era of spoils. So Guiteau thought, if I assassinate Garfield, Arthur will become president, and then Arthur will reward me with the position that I'm seeking. And one of the positions that Guiteau was seeking was the position of ambassador to France. So not a low-level position, but instead a very high-level position. He thought that Arthur would pardon him for assassinating Garfield. Clearly, that did not happen. Chester Arthur, yeah, no, it's crazy, isn't it? Chester Arthur actually started to advocate a lot of Garfield's policies once he became president after Garfield's assassination, especially the policy of merit-based civil service hiring. So Guiteau did not get a position in the government. Guiteau did not get pardoned. Guiteau was executed for the assassination of James Garfield. But that assassination of Garfield was the triggering event that really galvanized public opinion around the idea that we need to replace this era of spoils with this era of merit. We need to start hiring people not based upon their political affiliation, because see what happened when we do that, but instead we should hire people based upon their knowledge, skills, and abilities. So that's where we enter George Pendleton. George Pendleton, for many years, had carried around with him in his suit pocket draft legislation to create a merit-based civil service system. It had gotten very little to no traction in Congress until after the assassination of President Garfield. That was then his policy window, as John Kingdom would have called it last week, opens up the policy window so that he can introduce his legislation into Congress. It's passed by Congress, it is signed by President Arthur, and it becomes the law known as the Pendleton Act. The Pendleton Act, when it was signed by Arthur in 1883, creates this merit-based system of hiring and moves us from the era of spoils into the era of merit. So now we are hiring people not based upon who they know, but we're hiring them based upon what they know. So if you want to look at the three eras, in the era of gentlemen, we were hiring people based upon who they were. In the era of spoils, we were hiring people based upon who they knew. In the era of merit, we're now hiring people based upon what they know, their knowledge, skills, and abilities. This Pendleton Act was signed into law in 1883. So 4 years before Woodrow Wilson wrote that very famous article that we read and discussed the study of administration in 1887. So a lot of the things that Wilson was talking about in his article can be directly traced to the passage of the Pendleton Act in 1883, the introduction of merit-based civil service. And so, as Wilson told us, what we did is we took the British civil service system and we took some of those innovations from the British civil service system and we incorporated them into our system of public employment hiring. So, the most prominent one that we've talked about before, the use of examinations. So, we will have these open competitive examinations. And people will sit for these open competitive examinations, and we will then hire them based upon their performance on these exams. So this is where our examination-based hiring comes from in the Pendleton Act in 1883. So as of 1883, we are now in this era of merit, and we're hiring people based upon their abilities as opposed to the political party that they serve it or they support. Also in the Pendleton Act, we were providing political insulation for these administrators. So if we're hiring them based upon merit, they should then keep their positions based upon their job performance. So we're going to insulate them from undue political influence. So we're going to say these merit-based civil servants cannot be removed from their positions for political partisan types of reasons. So they got these protections from political influence. However, in the Pendleton Act, we gave them these protections from politics, but we didn't really demand a whole lot back from them in terms of avoiding politics themselves. We didn't really get that until the Hatch Act several decades later. So in the Hatch Act, we realized that yes, we should protect these administrators from political influence, but these administrators should not be engaging in politics in the course of their jobs as administrators. They should not be using the resources from their office. They should not be using the time that they're being paid to be an administrator in order to advocate for and campaign for partisan campaigns, partisan political parties, partisan types of candidates. You should be precluded from using your office and using the resources of your public office for any type of partisan campaigning. And that's what the Hatch Act did. It placed these political limitations on these career civil servants so they could not engage in partisan political types of activities while on the job or using the resources from their office. That Hatch Act was at the national level. After the Hatch Act was passed at the national level, we then ended up getting all these mini Hatch Acts or little Hatch Acts that were passed across all the different states. Here in California, we have what you would consider to be a little Hatch Act as well. And in our little Hatch Act, we place limitations on the political activities that can be engaged in by state civil servants. So what we have done here is we have tried to pull politics out of public employment to make sure we're hiring people and retaining those people based upon their merit and based upon their performance. Fast forward into the 1970s. And so the Pendleton Act was passed in 1883. Then nearly 100 years later, in 1978, We had come to the realization that from the passage of the Pelton Act in 1883 until the late 1970s, Congress had continued to pass piecemeal legislation to make adjustments here and there to civil service and merit-based employment. So much so that merit-based employment was basically a patchwork of a lot of different piecemeal, very confusing, and sometimes contradictory laws being passed by Congress. So much so that by the 1970s, these merit-based civil servants really did not know what they could and could not do without violating civil service principles. So in 1978, we get this massive piece of legislation called the Civil Service Reform Act. And the Civil Service Reform Act was designed to basically modify our entire career civil service system to make it easier to understand and to make it clearer to civil servants how they could help protect their own civil service protections. So if someone felt that their civil service protections were being violated by a supervisor for political reasons, there is a lot of ambiguity and a lot of confusion about what they could do to advocate for themselves, to protect their civil service rights. So the Civil Service Reform Act was all designed to try and reform the entire civil service system through the creation of several new types of entities. So some of those entities I have listed there on the screen for you, and let's very briefly talk about what they were, how they operate today, some of their advantages and some of their disadvantages. So one thing we realized in the Civil Service Reform Act is that we needed an organization to essentially oversee the hiring process, the recruitment and the hiring process. And so the organization that would do that is OPM, which is the Office of Personnel Management. Oops, typing and talking. Office of Personnel Management, OPM. Office of Personnel Management was designed to be the central clearinghouse for the personnel function, human resource management function across the entire federal government. So OPM was responsible for whenever there is a vacancy in an organization. OPM would then put together the position vacancy announcement, would distribute that announcement, would then solicit applications, would create an examination for that position, would then administer the examination, would score the results of that examination, then would take the top scores on that exam, usually either the top three or the top five scores, a rule of three or a rule of five, and create an eligibility list. Then that eligibility list would then be given to the hiring agency, and the agency could only interview and hire off of that eligibility list. So it's a very top-down micromanagement approach to managing the recruitment and the hiring process in the federal government. OPM is still with us today. OPM today is much more decentralized in that we don't rely nearly as much on examinations as we did in 1978. So there aren't those examinations to create and to administer. Also, OPM decentralizes and devolves a lot of the hiring responsibility today to the individual federal agencies. And so OPM is more in a support role today than it was back in 1978 when it was created as the central clearinghouse for the entire hiring process. But OPM was there to try and help us understand how we could hire people and maintain these merit types of principles. Then the second organization that was created is the Merit Systems Protection Board. So Merit Systems Protection Board. I just had another typo. Merit Systems Protection Board, or the MSPB. The job of the Merit System Protection Board was if there was a career civil servant who felt that their civil service protections were being violated, so they were being demoted for a reason that was other than their performance. They had a supervisor who belonged to a different political party, and so they were demoting them based upon that. or they were blocking them from a promotion that they qualify for, again, on political types of reasons, then that individual employee could then take their case to the Merit System Protection Board. So they would file a case with the Merit System Protection Board. The Merit System Protection Board would then kind of operate as a quasi-judicial body where they would review that case, they would hear that case, they would hear testimony on that case, and then they would render a decision on the case. So either this person's claim is valid that yes, their civil service protections are being violated. If they find that yes, civil service protections are being violated, then the MSPB could go back to the agency and could then order the agency to take certain types of actions to remedy that violation. So, for instance, if someone was denied a promotion that they were qualified for on political grounds, MSPB could go back to the organization and say, you must promote this person to this position, and you must also provide them with back pay for all the days or weeks or months that they should have been in this higher level position. If someone has been terminated for political reasons, the MSPB could go to the agent and say, you must rehire this person and you must make them whole by giving them back pay for the time in which they were not in this position. So that's the Merit System Protection Board. It operates so that if an individual employee saw their merit principles being violated, they could take their case directly to the Merit System Protection Board. Now, things have changed and the sands are shifting in terms of career civil service protections. In terms of the Merit System Protection Board, over the past 15 or so months, the Merit System Protection Board lost its director, and that the head of the Merit System Protection Board was fired by President Trump and has been replaced with a new appointee by the Trump administration. The current, or at then, the current Merit System Protection Board head was a Biden appointee. Still had time left on their term, but before their term ended, President Trump came in and fired them, replaced them with his own employee. And so now the Merit System Protection Board looks different than it did before the current administration took over. That raised this big question of, well, can a president come in and fire a commissioner in an independent agency? Someone who had been appointed by a previous president, had been confirmed by the Senate. Can the current president come in and fire that person? So that's one case that then went into the court system. Now, I'll tell you how that was resolved in a second. But let's move on to another organization because it's a very similar story, and that's the Office of Special Counsel, or the OSC. That stands for Office of Special Counsel. The Office of Special Counsel was initially created within the Merit System Protection Board. So it was part of the Merit System Protection Board. The job of the Office of Special Counsel, as we know from our discussion of accountability and ethics a few weeks ago, is to protect whistleblowers. You are a whistleblower if you see something unethical or you see some violation of civil service protections going on in your agency. It may not affect you directly. If it affects you directly, you can go straight to the Merit System Protection Board. However, if it doesn't affect you directly and it's affecting other people in the organization, then you can blow the whistle to the Office of Special Counsel. The problem in 1978 is since the OSC was part of the Merit System Protection Board, it did not have its own budget, it did not have its own staffing level, and it was completely reliant upon the MSPB. What that did is it created a huge backlog of whistleblower cases that the OSC didn't have the resources or the personnel to get to. The backlog became so bad that Congress, in the Whistleblowers Act, about a decade or so later, then pulled the Office of Special Counsel out of the Merit System Protection Board and made it an independent agency with its own staffing and with its own budget. So OSC is a place that a whistleblower would go to blow the whistle on their agency. Well, the head of the Office of Special Counsel was also fired by the current administration. The Office of Special Counsel had, I think his name was like Dellinger or something like that. He was fired by President Trump. He decided to take his case into the court system. And so he won at the district court level. He did fairly well at the appeals court level, but there was an injunction placed upon his firing. And then his case was going up to the Supreme Court. However, by the time the case got to the Supreme Court for final resolution, his term would have already expired. Same type of thing as with the head of the Merit System Protection Board. Because what the president is doing is the president is firing these folks when they still have 6 or 8 months left on their term. They're replacing them with his own appointees. And then by the time the case makes it all the way through the court system, that term would have already expired. And so once this case got to the Supreme Court declared the case to be moot. And they said it's a moot case because the term is already ended. And so the person would be out of that position anyway. And so we never got a resolution from the court about whether or not the president has the ability to fire the head of an independent agency like the Office of Special Counsel. Well, to keep this story going, then there's a fourth organization, the FLRA, which stands for the Federal Labor Relations Authority. The Federal Labor Relations Authority. The Federal Labor Relations Authority was created to oversee the collective bargaining process at the federal level. So the collective bargaining process, and we'll talk more about that in a couple of minutes, but the collective bargaining process is this negotiation that goes on between employee unions and agency management. And so it's supposed to be a collaborative process whereby they come to an agreement, and that agreement is then a collective bargaining agreement. Well, the agency that oversees that bargaining process is the Federal Labor Relations Authority. Federal Labor Relations Authority got off on the wrong foot, if you will, with federal employee unions because very soon after it was created in 1978, in the early 1980s, we had the air traffic controller strike. President Reagan warned air traffic controllers that if they went on strike, that he would fire them. Several of them went on strike anyway, and he fired all the striking air traffic controllers and hired new air traffic controllers to replace them. The Air Traffic Controllers Union said this is a violation of collective bargaining law. We have the ability to strike. That's one of the work actions we can take in the collective bargaining process. They took their case to the Federal Labor Relations Authority. The Federal Labor Relations Authority sided with the Reagan administration, saying that these air traffic controller positions were directly related to public safety. And because they're directly related to public safety, air traffic controllers do not have the right to go on strike. So that was a decision the FLRA made that obviously angered the Air Traffic Controllers Union and really kind of put a pall over the way in which public employee unions viewed the Federal Labor Relations Authority. They start to view, for right or wrong, the Federal Labor Relations Authority as always being geared more towards supporting administration. But the Federal Labor Relations Authority is there to try and govern this collective bargaining process. Well, to keep the story going, President Trump fired the head of the Federal Labor Relations Authority. Here again, you had an individual who had a term that was ending, I believe it was in July of 2025. President Trump fired this individual several months before their term ended. Again, by the time the case would work its way through the courts, that term would have been over, and so it would have been declared to be a moot case by the Supreme Court. Because of the timing of these firings, in terms of not having all that many months left on the term of these people who are being fired, we have yet to get a true resolution from the Supreme Court on the question of can the president fire the head of an independent agency? The head of an independent agency who had been appointed by a previous president had been confirmed by the Senate. So we're still kind of waiting for a case where we can actually get the answer to that constitutional question. But right now, if you are they didn't once they made it through the district court level, and a couple of these cases made it to the appeals court level. But I think everyone kind of saw what happened with OSC case and knew that once it got to the Supreme Court, it would just be declared to be a moot case. So they went elsewhere and they went off and got other jobs, and we've really never had any restitution for those individuals, or more importantly, any answer to that big constitutional type of question. So the issue that we have here is we've got this big constitutional question that really has not yet been answered, but we don't know if we're going to get it answered because the firings have been very strategically done so that they're done a few months before the term would end. So we have a situation where now we have a MSPB and a OSC and a FLRA that have new leadership. In the case of the Federal Labor Relations Board, it was very much understaffed and it was missing a lot of commissioners. And so the current administration not only replaced the lead commissioner, but also replaced a lot of the other commissioners. And so the majority of the commissioners in the Federal Labor Relations Authority, the majority of them on the Office of Special Counsel and in the Merit System Protection Board, the majority of those individuals are now appointees of the current administration. So certainly there has been some policy influence, obviously, and I'm not going to get into that, but there's certainly been some policy influence from the White House over these types of agencies. But these are the agencies that were created in 1978 in order to try and protect the career civil service system. We do know that the Trump administration also signed an executive order that would strip career civil service protections from a large number of federal employees. That's another question constitutionally that we're going to have answered eventually by the Supreme Court. So far, district courts and appeals courts have found that action in the executive order to not be constitutional. But again, as with everything else, you got to wait for it to percolate its way all the way up through the court system before we get those final types of answers. But there is one more organization that was created under the Civil Service Reform Act that also made a big change to our career civil service system, and that's the SES. And that stands for the Senior Executive Service. And the Senior Executive Service was designed to try and bridge the gap between political appointees and career civil servants. So when you look at a federal agency or a federal department, that agency or that department, at the very top of that agency or that department, it is being run by political appointees. Political appointees who are appointed by the president, and in many instances, not all, but in most instances, then confirmed by the Senate. Those are political appointees very much in the same vein as a era of spoils. And that's at the very top level of cadre of our agencies and departments. Then the vast majority of the bureaucrats who work in those departments are career civil servants, hired based upon their knowledge, skills, and abilities. They are hired based upon merit principles. The problem that we had there is that political appointees who are running these agencies and departments, since they were appointed by the president, they have strong allegiance to the president, regardless of what president it is and what political party it is. And so they are there to try and put in place the policy objectives of that president. Career civil servants are there for an entire career. So whereas a political appointee may be there for 2 to 4 years, typically not longer than 4 years. If they're really lucky and serve through 2 terms, it might be up to 8 years. Most of these political appointees don't make it 8 years, even in a 2 term presidency. So they're very temporary. They're there for a short period of time. Your career civil servants are there for 25, 30, 35, 40 years. So as career civil servants, if they don't like the policy directives coming from these political appointees, their argument is, well, I'll just wait them out because in another 4 years, there'll be a different political appointee here leading the agency, and maybe I'll agree with the policy directives of that political appointee. So you have political appointees going in one direction, and you had your vast majority of career civil servants going in a different direction. So what Congress wanted to do is bridge that gap between the political appointees and all the career civil servants. And so they created this thing called the Senior Executive Service in order to do that. And to kind of explain how the Senior Executive Service works, we have to understand the general schedule. And I think we've mentioned this in a previous class. The position classification system at the federal level is what's called the general schedule. Technically, prior to 1978, the general schedule, the position classification system, would run from a low of a level of GS1 up to a high of a GS18. There really aren't any positions at GS1. I mean, GS1 is technically on the general schedule, but the first real position would probably be a GS3, and a GS3 would be kind of like a student intern. A summer intern would be a GS3. But it would run all the way up to a GS18. GS18 was the top career civil service position in a federal agency or department, just below the political appointees who are running the department or the agency. So what we did with the senior executive service is we took the top three levels in the general schedule, GS 16 through 18 positions. So just those very top three levels, GS 16 through 18. And we peeled them out of the career civil service and we put them into this new service known as the senior executive service. So today there are no longer GS 16, 17, and 18 positions. Those positions have now become ES 1 through 5 positions, ES standing for executive service. So if someone is an ES1, that means that they are in the senior executive service. Well, so what? The so what here is that when you move a person's position into the senior executive service, the advantage of that for that individual is they then qualified for bonus pay, essentially pay for performance. So if their organization performed better and did a better job of achieving its goals, then bonus pay would be available to those members of the senior executive service in that agency. That was one of the primary advantages. A second main advantage is that it provided more flexibility, where the senior executive service members could more freely move from one agency to another agency. So those are the selling points. The problem was that bonus pay never materialized. So Congress made these promises, but then Congress realized it didn't have the money to make good on those promises. Every year we are running a federal budget deficit. So therefore, there wasn't money to provide these employees that bonus pay. So the bonus pay never materialized. And also, when we move these people into the senior executive service, the other downside was not only did they not get this bonus pay, but they had to give up some of their career civil service protections, which meant that it was much easier to fire these employees than it was when they were in the career civil service. So basically, members of the senior executive service got all the bad parts, but none of the good parts. And so that's why today, if you would ask a member of the senior executive service, would they recommend a younger employee to be part of the senior executive service? Survey after survey shows that over 75%, 70 to 75% of those SESers would say no, they would not recommend this to a younger employee. But the whole goal here of the senior executive service was, again, to bridge that gap and fill in that void between political appointees and all the rest of the career civil servants. So we've got all these five organizations. They're still with us today. They're still operational today. They're just operating a little bit differently than the way in which they operated in the past. And again, we've got a lot of unresolved legal questions that hopefully will be resolved in the future so that we'll have a better take on what the future of career civil service will look like in the federal government. There is also an executive order that was signed by the president that would strip away collective bargaining rights from about 1 million federal employees. And I think a lot of people saw that executive order and thought, well, that's not good from a civil service perspective, but it's just an executive order. Well, earlier this week, the Department of Treasury just voided the collective bargaining agreement with the union representing IRS agents. So IRS agents, they had a collective bargaining agreement with Department of Treasury, and that is no longer in effect, according to the Department of Treasury. That is now considered to be null and void. Here we go again. It's going to be another legal question that's going to have to work its way through the courts. You know how slow and laborious the process is of making it through the federal court system. So we're going to have to sit back and wait and see what happens with that. If it does make it up to the Supreme Court level and the Supreme Court supports the president's ability to take away collective bargaining from career civil servants, then this entire discussion we're having tonight is going to be changed and be dramatically changed. So we'll have to see how the Supreme Court chimes in on that. And yeah, we have seen a large number of executive orders, more executive orders in the past 15 months than you'll typically see in 4-year term of another president. So a lot of work being done through executive orders. That's all part of a unitary executive theory. And the unitary executive theory vests power within the chief executive. And the primary tool then that the chief executive would use would be an executive order, as opposed to working through Congress to get legislation. So a lot of this is being done through firings and through executive orders. So I guess the future of career civil service is TBD, and we're going to have to wait and see what the courts say. But the entire nature of civil service at the federal level may continue to change over the next couple of years. Here in the state of California, we have a civil service system as well for state employees. That civil service system is obviously governed here in the state of California by the state of California. So it's a separate civil service system, separate and distinct from the civil service system at the federal level. We also tend to have a pretty robust system of collective bargaining here in the state of California as well. We have a somewhat permissive scope of collective bargaining that we'll talk about in a few minutes. So I think the civil service system and the collective bargaining process here in California, it won't be as affected as what we've seen at the federal level. So that kind of serves as our backdrop for understanding federal employment and how we decide who becomes a public administrator, how do we decide who becomes a public employee. Our next question then is how do we then manage these public employees? And the movement really has been away from classic organizational theories and more toward human resource management theory. And when I first started teaching, my first class was a public personnel management class. I took that public personnel management class. First thing I did was put in a curriculum proposal to change the name of it from public personnel management to human resource management. I think it just kind of characterizes how we take much more of a theory Y approach, as Douglas McGregor would tell us, as opposed to the theory X approach that came out of the classical school. So how do we employ that theory Y approach to managing people as human resources? Well, as we manage our human resources, we go through several different types of functions. Obviously, the first function in human resource management is recruitment and hiring. We have to staff our organizations. Luther Gulick taught us that. Graham Allison talked about that here in this class. We have to go out there and bring people into our organization as employees. Recruitment is obviously much different in the public as compared to the private sector. And we've talked about this a few times already this semester. We know that the public recruitment process tends to be a much more protracted, a much more complex process than we typically see over in the private sector. We know that if you're working in the public sector now, it took you probably a long time to get your position. It wasn't just same day hiring, I would think, probably if you're in the public sector, as it can be in the private sector. In the private sector, you're an at-will employee. So you can be interviewed, you can be hired, you can go to work the same day if they can get you on payroll. Obviously, in the public sector, since you are a merit-based career civil service type of hire, you have certain career civil service protections. And so we're going to take a much more deliberative process in terms of recruiting and hiring you. We also are interested in not just effectiveness and efficiency, but also social equity, representative bureaucracy. And so we're going to want to obviously do a lot of targeted recruitment. And so when we do recruit, we do targeted recruitment. We reach out to targeted populations to try and create the most diverse applicant pool as possible so that we can then diversify our workforce. I may have told you before, but here at Long Beach, whenever we go out there to hire a faculty member, and fingers crossed, I hope we'll get a chance to hire a full-time faculty member next year, but I'm not counting on it because we've been told, well, I won't get into that, but we've been waiting to hire a new faculty member for about 4 or 5 years now. So our most recent full-time tenure track faculty member just got promoted to associate professor. So that shows you it's been over 6 years since we've had the opportunity to hire. But when we do it here at Long Beach, we usually send out our position vacancy announcement, usually in July. That announcement must be vetted through not just our department in the college, but also through the Office of Equity and Diversity. Then once we put out that recruitment, we also have to have a recruitment plan as well, where we have to say what sources we are going to be advertising in. We have to do targeted recruitment, and so we'll identify sources that have better outreach to historically underrepresented populations. And that's something that, again, has to be approved by the Office of Equity and Diversity. When we do get our applications that come in, we typically have a closing date of usually late August or so. Once we close applications, we have our applicant pool. That applicant pool then must also be approved by the Office of Equity and Diversity for adequate diversity. If not, then we have to cancel it and go out and do a new recruitment. Now, I've gone through this. I've led this process 3 times when I was department chair. We've never been sent back to the drawing board with it. It's always been approved. But once that applicant pool is then approved, then you can start going through your application. So we usually do that throughout the fall to put together a list of semifinalists. Those semifinalists are usually identified somewhere around November or so. That pool of semifinalists must then again have to be approved by the Office of Diversity and Equity and Diversity. Once they've approved that semifinalist pool, we then have to have our interview schedules. The questions we ask also need to be approved. Once that's approved, we can then schedule our Zoom calls or our telephone calls and do those semifinalist interviews. Once we've concluded those are usually done by the end of the year. Then in January, we will put together a list of our top 3 finalists. That finalist list must then again be approved by the Office of Equity and Diversity. We then bring those 3 folks to campus for an interview. Typically, we're then ready to identify our top candidate, which we then recommend to the dean and the Office of Equity and Diversity, usually sometime in February. And then hopefully an offer goes out and an offer gets accepted by the beginning of March. So the process is run from about the middle of July until the beginning of March. And that's our hiring process. Again, it's a very long, very protracted process. You run the risk in those long processes of losing candidates. And we have lost a lot of very good candidates to private schools that have been able to hire much quicker than we are able to hire. Several years ago, we were hiring, this is probably a good 20 years ago now. We were hiring a full-time lecturer. We identified our top candidate, was a great candidate, but it took us so long to get there that by the time we got there, she had already accepted a lecturer position at USC. So we lost her to a university up the road. And yeah, well, oftentimes in HR, there can be separate diversity departments, or sometimes the diversity checks are being done by the Office of Human Resources. It really depends upon the size of the agency. Large agencies typically will have their own offices of diversity. Now, again, having your separate Office of Diversity today from a political perspective could put a target on your back. And so some organizations are kind of renaming their offices of diversity so they don't have the word diversity in them. Larger agencies will have a separate office to do that. Smaller agencies will be done within the HR office. Here at the Cal State Long Beach, we have a separate Office of Equity and Diversity that operates alongside the Office of Faculty Affairs, which operates alongside the Office of Human Resources. And so when we go out there and do faculty hiring, we work with Office of Equity and Diversity, and then separately, we also then work with the Office of Faculty Affairs. So it all depends on the agency and their size and their scope. So it's a very long, protracted process. But then we have to, once we have our finalists, we then have to decide which of those applicants to select. So our second function is then the selection function. How we select employees has changed. So historically, especially at the federal level, we relied heavily on these examinations. So examinations, the whole process of examinations created back in 1883 in the Pendleton Act. We still use examinations for certain positions today if they're highly technical types of positions. If there are discrete skills that are required in the job that can be tested for, we may still use examinations. But the vast majority of our positions now are hired based more on knowledge, skills, and abilities, this more holistic review of a candidate's file, as opposed to that candidate's performance on an examination. At the federal level, the type of examination that was historically used was what was called the PACE exam. And the PACE exam stood for Professional and Administrator Competency Exam, I believe is what PACE stood for. The problem with examinations is a problem with, number one, validity, and number two, a problem with bias. So in terms of validity, if we're going to use an examination, we need to establish that that exam is a valid predictor of job performance. And sometimes that is difficult to do. There are lots of different types of validity. One type of validity is what's called content validity. And if you've had research methods, you've talked about content validity in the past. Content validity essentially means that the content of the exam is equivalent to the content of the job. So the questions on the exam will be reflective of the types of skills that you need in order to do this job effectively. Very famous case many years ago called Griggs versus Duke Power Company. And the Griggs versus Duke Power Company case, this was the issue at hand, was the content validity of the examinations used for hiring. The problem was the organization was using examinations that had mathematical questions on there, and the exam was for a custodial position. And that custodial position, you didn't need to know all of this higher order math. And so they were essentially using this examination to screen out candidates from a job that those candidates would have been able to do very well. So the content of the exam must match the content of the job. Another type of validity is what's called criterion validity. Criterion validity looks at how well your performance on the exam correlates to performance on the job. And there are two different ways to measure criterion validity. I won't get too much in the weeds here, but it is important for examinations. And the two types of criterion validity are predictive and concurrent. Let me explain both of those very quickly. So a predictive validation method to measure criterion validity would be you administer the examination, you score the examination. You then take your top scores and then a sample of your lowest scores, and you hire those two samples into your position on a probationary basis. You then evaluate their performance while they're on probation. Those who performed well on the exam should also be good performers on the job. Those who perform poorly on the exam should have poor performance evaluations. That's a predictive type of approach because we're asking how well does performance on the exam predict performance on the job. Now, obviously, this is kind of a classroom-based example because if you don't have a whole lot of resources, you're not going to hire people who you think will probably perform poorly on the job. So this is something that's done purely to measure the validity of the examination itself. The reverse of a predictive approach is what's called a concurrent validation method for criterion validity. In a concurrent approach, you will then administer this examination to your current employees. So you'll administer it to your top performers, you'll administer it to your bottom level performers, and then you'll see how they perform on the test. Those who are good performers on the job should perform well on the test. Those who are poor performers should perform poorly on the test, known as a concurrent type of validation method. Then we also know that these exams tend to be somewhat biased, and they have some cultural bias that are built into them as well. Because of the problems with bias, because of the problems with the lack of validity, we have really started to move away from the use of examinations and again, base our hiring decisions on a more holistic review of knowledge, skills, and abilities. We'll look at someone's resume. We'll look at their education. We'll look at their experience levels. We'll look at their references, their recommendations. If they happen to have a student learning portfolio that they completed their master's program that shows an example of a budget analysis, we can look at that as part of the hiring process. So we'll do a much more holistic type of a review. So it's really very much a focus more on KSAs than it is performance on a specific type of examination. Another approach that we can use in selection is the use of an assessment center. Now, these can be very expensive because in an assessment center, what you will do is you will set up a simulated work environment called an assessment center. You'll then bring your applicants in and have them do the work they'll normally be doing on the job on a daily basis here in this assessment center, and then evaluate the quality of the work that they're doing. Well, we know about the Hawthorne effect from Elton Mayo. We know the Hawthorne effect tells us that when you observe someone, they oftentimes behave differently than when they are not being observed. So obviously they're going to work harder, they're going to be more productive in this assessment center because they want to get the job. So sometimes it's not a true indicator of how they're going to perform once they are on the job. In terms of how to select people, just put it in the context of a graduate program when we're selecting students for the MPA program, we do not use the graduate record examination. I think it's still called that, the GRE. Every now and then, every 7 years, we have a site visit team that comes to visit us for the purpose of accreditation. And almost every time they ask us the question, why don't you use the GRE? Say you're a popular program, you have more applicants than you have spaces for, so why don't you use the GRE? Our answer is always that when we have done studies in the past, the GRE is a less reliable predictor of success in the program than someone's academic performance over their last 60 units of their undergraduate degree. We have found that the last 60 units of your undergraduate degree is a much better predictor of success in graduate school than the graduate record exam. So that's how we're kind of using more of the knowledge, skills, and abilities. Once you have hired someone, you obviously have to onboard them, and you'll talk more about the details of that in 577, kind of beyond the scope of this class to really get into onboarding processes too much. But once you hire them and you onboard them, then the third function you have to be concerned with is allocation and evaluation. We need to divide the work up in our organizations. So we know from way back in Max Weber, one of his major principles was division of labor. All of our organizations will have some aspect of division of labor. So we have to decide who does what within our organizations. That's what's known as the allocation function, how we allocate work. How we allocate work will go through several different steps. One step that we'll use in the allocation of work is what's called the job analysis. And if you do work in HR, you've probably conducted these job analyses before. But in a job analysis, we will analyze each individual job, looking at the tasks that are done on a daily basis on that job, the percentage of time that is spent on each one of those tasks. We will deconstruct each individual job within our organization and analyze those jobs individually. So we analyze the jobs in isolation. So here's a job analysis for the job of police chief. Here's one for the job of a sergeant. Here's one for the job of a patrol officer. And we'll do a different job analysis for each position. Once we have completed a job analysis for each position and we have a good handle on what the tasks are that are being done on a daily basis, the types of skills that are required to do those jobs, the amount of supervisory responsibility, all those types of things that really make up that job, then we move to the next step, which is a job evaluation. In a job evaluation, we'll take the results from each of those job analyses and we'll then compare job to job. And we do a job evaluation for the purpose of then creating a position classification system so we can then assign compensation. So each one of these steps builds on the previous one. So we take the results of the job analysis and then we compare job to job in a job evaluation. So, for instance, go back to our police chief versus patrol officer jobs. If we're doing a job evaluation, we'll take the position of police chief and we'll look at different components of that job, such as a police chief will be responsible for creating and managing the departmental budget. That's one of the core responsibilities of that police chief. Patrol officer probably will not have that as one of their core responsibilities. For the police chief will probably interact and interface with elected officials on a frequent basis. Patrol officer probably will not be doing that. The police chief will probably have the responsibility for, supervising employees, all the employees below them in the police department. Patrol officer probably won't have those same types of supervisory responsibilities. We'll look at conditions of work and the police chief. How dangerous of a job? What's the risk of physical harm for a police chief? Well, there, the police chief is probably going to score lower than the patrol officer who's out there on a daily basis on the streets, actually patrolling those streets. So we take all these different, what we call factors in the job. And the most common type of job evaluation that is done is what's known as a point factor job evaluation. And in a point factor job evaluation, what we'll do is we'll identify all the salient factors of each of those jobs. We will then assign points. So what we usually do is we'll have a weighting mechanism. The weighting mechanism will reflect how important that task is to the successful completion of a job. Then we'll take that weighting mechanism and multiply it times the point total, either from usually ranging from 1 to 10. So for instance, for the police chief, the interfacing and interacting with elected officials, that could be worth 20% of the job. The police chief will score 10 out of 10 on that because the police chief is the one who will be doing that on a daily basis, will be the one responsible for that. In terms of conditions of work, risk of physical harm, that is something we might say is worth, again, 20% of the job, but the police chief might score a 1 on that because the police chief is not out there on the streets, whereas a patrol officer would score 10 out of 10. So we assign points, we multiply the points by the weighting factor, we then sum those totals, and the jobs that have the largest total from this point factor evaluation are the ones that are then ranked highest on our position classification system. So ostensibly, the police chief will score the highest on this point factor job evaluation, and the police chief will then be ranked as the top position in the position classification system and then get the highest compensation. Patrol officer will probably be much more closer to the bottom of that position classification system and will then be assigned a much smaller salary. The idea of going through this process to create a position classification system means that we can then assign comparable worth to comparable effort. So we can see that the positions that are these highly responsible positions that require a lot of supervisory skill and a lot of supervisory responsibility, those are the ones that will be ranked higher on the classification system, and those will be at a higher pay grade and get higher compensation. So you see the job analysis led us to do a job evaluation. That point factor job evaluation allowed us to create our position classification system, which then allowed us to assign comparable compensation. Also, we will take the results from this process and we'll use the results to then create a position description. Every position within our organization hopefully should have its own unique position description. A traditional position description will list, here are the tasks that are being done on a daily basis. Here's the percentage of time spent on each one of those tasks. So in a traditional position description, you have a front desk receptionist type of position. That person will greet people when they enter the building. That's one of their tasks. And they will spend 40% of their time greeting visitors. The second task might be answering phones, and they might spend 20% of their time doing that, and so on and so on. That's a traditional position description. We get the information to create that description out of that job analysis that we have conducted. However, what is probably a better thing to do is instead of having a traditional position description, having what's called an ROD, which stands for a results-oriented description. And again, when you get to your 577 class, you'll talk about this in a little bit more detail. You'll see examples of this in more detail. But basically, a results-oriented description will then add on performance expectations. So this front desk receptionist will be greeting visitors upon their arrival. That's 40% of the time that they are spending. And the performance expectation is that every visitor is greeted every time and they are referred to the appropriate office 100% of the time. There is the expectation for how this person will perform in greeting and referring visitors. Telephone calls. The performance expectation might be that every phone call gets answered by the second ring and that the greeting script is used every single time a phone is answered. That's a performance expectation. The great thing of including those result types of expectations in an ROD is it then allows the employee to know what performance is expected of them so that when it comes time for your next step, which is performance evaluation, there are no surprises. Performance evaluation is difficult because before we were evaluating the job. Now we're evaluating the incumbent's performance on those job duties, and that's performance evaluation. Performance evaluation is difficult because no one really likes doing performance evaluations. Employees don't like performance evaluations because of the fear of what we call cognitive dissonance. That what will happen is most employees believe they are doing a good job. They then get a performance evaluation that tells them that they're not doing such a great job or gives them some constructive criticism. That creates this cognitive dissonance where they're getting information that they don't believe is necessarily true. So people don't like being evaluated, and employers don't like doing evaluations either. And that's for this whole fear of, as they say, playing God. The whole fear that there are so many important consequences that are associated with performance evaluations that you really don't want to preclude someone from going into a management training program because of a poor performance evaluation, or preclude them from being eligible for a promotion because of a poor performance evaluation. So when you have employees and employers who both don't want to do performance evaluations, you got a lot of resistance. But performance evaluations are extremely important. So much so that there is an article from several years ago by an author named Charles Fox. And Fox wrote an article where he likened performance evaluations to being what he called the keystone of the human resource management process. And when you think about a keystone, you think about an arch made of stones. The stone at the very top of that arch is the keystone. If you pull that keystone out, the arch is going to collapse upon itself. So the keystone is holding that entire arch together. Fox would argue that performance evaluations hold the entire human resource management process together as well. So it's very important that we do a good job evaluating employee performance. There are different ways in which we can do it. Our goal in evaluating performance of our employees should be to provide both summative as well as formative feedback. Summative feedback is just if you have like a graphic rating system where you had strongly agree, agree, neither agree nor disagree, disagree, strongly disagree. So the employee is always punctual to work. Strongly agree, agree, so on and so on. That is summative for feedback because the employee will see, well, my manager said that they strongly agree that I'm always punctual to work. Okay, great. That's summative. Maybe you would have excellent, good, fair, poor as your Likert ordinal scales. Well, if you end up getting half excellent and half goods, well, you're doing pretty well, but you're not getting a lot of feedback in terms of how you can do better. It's very summative, it's not very formative. So a graphic rating performance evaluation system, whereby we're using these Likert ordinal response scales, very quick, very easy to do. The problem is obviously it's summative and it doesn't give a whole lot of formative feedback. I also have listed there things like forced choice. Forced choice is just where you give a series of different answers to the evaluator and they select one of those answers. Ranking is just what it sounds like. You rank the performance of employees from a high down to a low. Essay is where you give a narrative amount of formative feedback. So if you want formative feedback, you need to have some type of an essay component that's built into your graphic rating system. But the one that I will emphasize for our purposes here is the last one listed on the screen there for you, and that's a BARS approach. BARS stands for a behaviorally anchored rating scale. So a behaviorally anchored rating scale. In a behaviorally anchored rating scale, we are anchoring our ratings to specific types of behaviors that are being exhibited. So, in a very simple format, just think about your grading rubrics that you have in some of your syllabi. In a grading rubric, you may have a rubric that says a grade of A will be this behavior is demonstrated. So, get an A on this paper. You would have to have a paper that is complete, that utilizes course material correctly, that develops at least one new insight into the issue, and adheres correctly to APA format. That would be the behavior that will earn you an A on the paper. Then to earn a B on the paper, the behavior may be all the same, except you may not have to develop a new insight. And then that would be the behavior that earns you a B, and so on and so on. So we anchor the rating to a specific type of behavior. That is an excellent way to combine summative and formative evaluation purposes together. They get a summative evaluation at A, B, C, D, or F, and they also get formative in terms of this is the behavior you exhibited. If you want to move from the B level to the A level, here is the A behavior that you would have to exhibit in the future. The moral of the story of the performance evaluation, though, is whatever format of evaluation you use, it is always helpful to include the person who is being evaluated in the design of that evaluation. It goes back to what we learned with Pressman Waldowski and what we learned with Martha Durthick. If you include people in the development of something, they are going to be more likely to trust the results of that development of that decision. So if they're involved in putting together the evaluation system, they are going to be more likely to accept the results of that evaluation system, even if those results are not what they initially expected. Even if those results create some constructive criticism or formative feedback, they're much more likely to accept that feedback if they were involved throughout the entire process. Then there is somewhat of a misunderstanding among the public when it comes to career civil servants that you cannot discipline, sanction, or terminate a career civil servant. That is not true. You can't. You just have to make sure that you document the process, because public employees as career civil servants, they keep their jobs and they receive their perks, whatever, based upon their performance, and it has to be performance oriented. For public employees that are unionized, if they are being sanctioned or disciplined for something other than performance, they have a grievance mechanism that they can follow in their collective bargaining agreement. So what we need to do is when we evaluate someone's performance, if we identify subpar performance, then we have to provide them with training and development opportunities to remedy that performance. Then after they have that training and development opportunity, then we can reassess their performance again. If it's still subpar, we have to offer more training and development, then reassess their performance, and so on and so on. At every step of the process, we need to document, because you cannot fire someone, a career civil servant, based upon one poor performance unless they're on probationary status. As long as they're not on probationary status, you cannot fire them based upon one poor performance. You have to establish a documented pattern of poor performance, followed by availability of training and development, followed by poor performance, and so on and so on. So in terms of discipline and sanctioning as your fourth and final function of HR, that has to be predicated upon a lot of documentation and establishing a pattern of behavior. But that just kind of introduces you to the major functions of human resource management. All the specific details within those functions, those are things that you will talk about when you get into your PPA 577 course. But before we walk away from this topic of managing human resources, I know that we're overdue for a break. The last thing we really do need to acknowledge that you'll again talk about more in 577 and then talk about a lot if you go on and take an elective course that we offer, which is 575 Employee-Employer Relations, is the influence of unionization. We know that public administrators tend to be unionized at 3 times the rate of their private sector counterparts. So we not only have career civil service protections that we have to abide by, but we also have to be knowledgeable about the provisions in this collective bargaining agreement that comes out of the collective bargaining process between unions and management. Now, as I mentioned, we're going to have to see how the courts interpret the executive order that has removed collective bargaining protections from career civil servants at the federal level. We'll have to see if the bargaining unit for IRS agents challenges the voiding of their collective bargaining agreement, the Department of Treasury. If so, we'll see what the courts say about that. But we have collective bargaining at the federal level, and we also have collective bargaining at the state level as well. Collective bargaining at the federal level is a little bit different than what we see at the state level because of what we call the permissive scope of bargaining. The scope of bargaining speaks to the types of issues that can be negotiated over between unions and management in the collective bargaining process. Some states have a very permissive scope of bargaining, some have a very restrictive scope of bargaining. Permissive scope of bargaining, California has a relatively permissive scope of bargaining. Wisconsin historically has had a very permissive scope of bargaining. States like Alabama and Mississippi tend to have very restrictive scopes of bargaining. So it just speaks to what issues can be collectively bargained over. To give you one prominent example at the federal level, compensation is not in the permissive scope of bargaining. So you cannot negotiate over compensation at the federal level. That sounds weird to us at the state and local level because compensation tends to be our number one issue that we are bargaining over. But the federal level, compensation of federal employees is established by Congress. Since Congress establishes compensation, you cannot collectively bargain and negotiate over it. So, how vigorous the collective bargaining process is really depends upon how permissive or how restrictive the scope of bargaining is. The problem we run into in collective bargaining is when we cannot come to an agreement. When the two sides are unable to come to an agreement, we have arrived at what is called an impasse in bargaining. Either one or both of the parties can declare an impasse, meaning that we cannot come to an agreement and we do not foresee the ability to come to an agreement in the future. Once an impasse has been officially declared, it then opens up some impasse resolution options that you can take advantage of. One impasse resolution option is what's known as fact finding. In fact finding, you will bring in an outside fact finder, an outside objective third party. That fact finder will come into the bargaining situation. They will look at everything that has gone on in the bargaining situation. They will talk to the union. They will talk to the management. They will then put together a fact finding report. The fact finder report is non-binding, so it doesn't make any recommendations. It doesn't bind either party to anything. It's literally just a statement of the facts as viewed by this fact finder. That fact finder report, once it is completed, is then embargoed for 2 weeks, meaning that no one can see what's in that fact finding report for 2 weeks, except for the negotiating team from the union and the negotiating team from management. It allows both sides to review that fact finder report for a 2 week period of time. Hopefully, if one of the two sides does not look good in the results of that fact finding report, then that side is going to have pressure on them to try and come to an agreement before this fact finding report goes public. So it's all meant to try and kind of light a fire under the parties who come to an agreement. But again, it is non-binding. A second resolution alternative is what's called mediation. The federal government maintains an organization called the Federal Mediation and Conciliation Service. The Federal Mediation and Conciliation Service contracts with trained federal mediators that it can then, upon request, send those mediators out to these negotiating processes to sit down at the table with the both parties and try and negotiate a result. One of my professors in my political science program of my undergrad school was a federal mediator. He had a contract with the Federal Mediation and Conciliation Service, so he was constantly flying all over the country to sit down and negotiate and try and get a negotiated agreement between two parties. Again, this mediation is usually non-binding in nature. It's just trying to get the process moving toward an agreement. If you really have an impasse and you need to have an agreement, you need to come to an agreement on a collective bargaining agreement, then arbitration may be the approach that you would want to use. And there's one specific type of arbitration called final offer binding arbitration that will guarantee that you will resolve an impasse. In final offer binding arbitration, a third party arbiter will come in, will tell the union, let me see your final offer, and tell management, let me see your final offer. We'll compare those two final offers and we'll select one. The selected final offer then becomes the collective bargaining agreement. That then becomes the contract. So it's a very high risk, high reward type of a situation. It's risky because if your final offer is not the one selected by the arbiter, then you're not going to like the contract. If it is the one that's selected, then obviously there's a big payoff and a big reward for you. It's not always as simple as just saying, well, we're going to negotiate and come up with an agreement, a contract, which is our collective bargaining agreement. Sometimes what you can do is if there are issues that you can come to agreement on, then you'll come to an agreement on those issues. But if there are other issues that you're not terribly happy about, you can always introduce what are called reopeners into the negotiation. So say, for instance, the management comes and management says, we want to give you a 5% raise. Union says we want a 7% raise. The management says, okay, we'll go with 5.5%. Well, the union's not really happy with 5.5%, but they want to get the contract done. So they accept it in a 3-year contract, but they will then introduce a salary reopener, which means that yes, we're going to have a 3-year contract we're going to agree to, but in 1 year, we have the ability to reopen the salary issue, and we can go back to the table to renegotiate salary. So oftentimes you'll see those types of reopeners. The organization that oversees collective bargaining at the federal level, we already identified as the Federal Labor Relations Authority. The one that oversees it here in the state of California is an organization called CalPERB. And CalPERB is the Public Employee Relations Board. And so CalPERB, if one of the two parties believes that the other party is negotiating in bad faith. So say, for instance, the management says, we want to offer you a 2% raise. Union comes back and says, no, we want a 4% raise. Management comes back and says, you know what, we're going to reduce our offer down to 1%. You cannot do that because that is negotiating in bad faith. That is the process known as regressive bargaining. So every offer that you make must be an improvement on your last offer. You can't go back, you can only make it better. So if the union says management is engaging in regressive bargaining, they could file a claim with CalPERB. CalPERB can then step in and can then tell management, you can't do that, that's regressive bargaining, and then can impose a settlement. So CalPERB has the ability to oversee collective bargaining here in the state of California. The assumption is that both parties will go to the table in good faith. Good faith bargaining means that both parties are going to the table for the purpose of coming to a negotiated settlement. We just to give you an example, the California Faculty Association, they are in the process of collective bargaining with the Cal State system. What they have done is the contract expired and they've actually extended it 3 times. And this third extension is now ending, I believe, the last day of this month, I think March 31st. So we'll have to keep an eye out and see if they do another extension, or if they don't do another extension, if they declare an impasse. If they do declare an impasse, which has happened frequently in the past, then you move on to one of these impasse resolution types of processes. So we see a lot more collective bargaining at the public sector as compared to the private sector. But really the moral of the story here is for managers in public organizations. When we are managing human resources, we not only have to be knowledgeable about the career civil service protections afforded to our employees, but we also have to be knowledgeable about the elements in the collective bargaining agreement. What that has meant is a lot of organizations, because this has become a very complex situation, a lot of organizations are now centralizing the human resource management function in their offices of human resources. So instead of having line managers do this on a daily basis, they will just centralize the entire HR function in their office of human resources. But collective bargaining is really a fascinating topic. In addition to PPA 575, employee-employer relations, there's also another course that's offered, PPA 570, negotiating dynamics. And negotiating dynamics will really get into the nuts and bolts of what you do at the negotiation table. And so if you're really interested in HR, I would strongly recommend thinking about PPA 570 and or PPA 575 as possible electives that you can register for in the future. I'm sorry, we've gone way past our time for a break. I apologize for that. I just want to make sure we get through all the information that you'll need in order to do a good job on the final assessment. Let's go ahead and take our break right now. If we can take a break until 5:45, come back at 5:45, and then we'll spend our last hour talking about our final topic, which is managing financial resources, to get you ready then for PPA 555. So take a break, come on back at 5:45. Okay, welcome back. Let's go ahead and get into our last topic for the course, which is managing financial resources, to get you ready then for PPA 555. I'm not going to get into a lot of details here because I know we have some limited time, the remainder of our class tonight. But what I do want to do is make sure we cover all the information that you are going to need to do that scenario on the final assessment. So, just by way of introduction in terms of public budgeting, we know that the primary document that we use is obviously a public budget. Some of you may work with public budgets on a daily basis. Some of you may have never worked with a public budget. But when we think about a budget, we think about a statement of here's the amount of money that we are spending in the next fiscal year, and this is what we are spending that money on. So that's a very basic type of idea, a very basic definition of what is a public budget. However, whenever I used to teach public budgeting, I would always offer a second, more nuanced definition, is that a budget really is a statement of priorities because we are always dealing with infinite demands that are being placed upon government from citizens, but we have to respond to those infinite demands with finite resources. Whenever infinite demands come into contact with finite resources, by definition, we have to make selections between different items. We have to make choices, we have to prioritize. So when you look at a public budget, you are really getting insight into what those priorities are for that society. So in some years, you may see an increase in education spending and a decrease in social services spending. That shows you that in that year, the priority is placed upon education. That's an important distinction. I love the so what questions. Well, so what? Well, that's an important distinction. When you look at a budget from the perspective of being a statement of priorities, by definition, you are elevating the importance of that budget. It's no longer just a statement of dollars and cents. Now it tells you what the priorities are of that society. So as you move forward into PPA 555, think about budgets from that perspective as really being a true statement of societal priorities. At the state and local level, there are two different budgets that we usually use, an operating versus a capital budget. Operating budgets are used for the day-to-day operations of that organization. And so that's where we'll pay for our salaries and our benefits and our utilities and our maintenance and our supplies. Those expenditures that keep the government operating on a daily basis, those are in the operating budget. And state and local governments will usually maintain a separate capital budget. And that capital budget will be for those high price tag, long lifespan, non-recurring types of capital improvement projects. And so that city hall, that recreation center, that aquatic center, those projects will then go into a capital budget. We typically separate capital expenses from our operating budget at the state or local level because most state constitutions will require that we at least balance our budget, if not run a surplus. So we're not allowed to have a deficit. If you had a $100 million recreation center capital project and you put that into your operating budget, it would blow a hole in that operating budget. It would make it impossible for that city to avoid a deficit. So we maintain separate operating and capital budgets. We also use these different budgets as an example when we talked about decision making. And remember, we talked about mixed scanning as a decision making model, sometimes rational, sometimes incremental. Operating budgets, that's incremental decision making. Capital budgets, that's more rationality. Because we're going to spend $100 million on a capital project, we want to put a lot of time and a lot of thought and a lot of effort in making those types of decisions. Now, that being said, the federal government usually does not maintain a separate capital budget because the size and scope of the federal budget is so large that a $100 million capital project won't make a bit of difference. And it's like a pebble in the ocean. But for state and local governments, we really do want to maintain a separate budget for those capital projects. We'll put together a capital improvement plan. The capital improvement plan will then prioritize all these different capital budgets over a 5-year capital projects over a 5-year period of time, where the highly prioritized projects will go into year 1 and then year 2 and so on and so on. But it's a separate, more rational decision-making process for capital budgeting. So let's go back to operating budgets. How do we put those operating budgets together? There are essentially 4 different steps in the budgeting process, and you'll cover these in 555, but just very briefly, they are preparation, formulation, execution, and evaluation. In preparation, we need to know how much money we are going to have to spend before we can decide how much money we are spending. So in preparation, what we'll do is we'll do our revenue forecast. So we'll go out there and we will do our work to forecast how much revenue we think we are going to generate in the next fiscal year. At the federal level, those revenue forecasts are done by the Office of Management and Budget, as well as by the Congressional Budget Office. Those revenue forecasts that come out of the Office of Management and Budget and come out of the Congressional Budget Office will oftentimes look much different from each other because OMB and CBO use a lot of different methodologies in putting their forecasts together. OMB's forecasts are oftentimes a lot more optimistic in that they will over forecast revenue as opposed to the Congressional Budget Office. So that's what happens at the federal level. At the state of California level, we have two organizations, the Department of Finance, which is the corollary to OMB, and we have the Legislative Analyst Office, which is the corollary to the Congressional Budget Office. They will also, in preparation, put together their revenue forecast for how much money they think we are going to generate for the next fiscal year. Then in preparation, once these forecasts have been created, then you'll have a call for budgets. And at the federal level, OMB, the Office of Management and Budget, will then put out a call to all the different agencies across the federal government for their budget requests. Then these agencies will submit their budget requests. OMB will then review those requests. They will then make changes to those requests, usually reducing those requests, and then assemble all those requests together into the presidential budget. The president's budget then goes to Congress typically in February. Whenever the president's budget goes to Congress in February, we then move from preparation to formulation. Here in California, we move from preparation to formulation when the governor's budget goes to the state legislature, usually sometime in late January. In formulation, this is where Congress is considering the budget. So at the federal level, the House and Senate budget committees will establish maximum amount of spending in each of the programmatic areas. Then the spending process will go into the appropriations committees in the House and the Senate and all of their attendant appropriations subcommittees. The goal is, through formulation, for Congress to put together 12 appropriation bills. Each of those appropriation bills will then lay out the spending for each of 12 spending areas. So you'll have a Health and Human Services appropriation bill. You'll have a defense appropriation bill. You'll have a Homeland Security appropriation bill. And so essentially, it's pretty much each cabinet department will have their different area of spending and a different appropriation bill. All 12 of those appropriation bills are supposed to be passed by Congress no later than September 30th signed by the president for the beginning of the new fiscal year on October 1st. Now, that appropriations process is for a type of spending that is known as discretionary spending. Discretionary spending is spending that Congress has direct control over. So if Congress decides we want to spend less money on this social welfare program, if it's something that's within their ability to do so, they can just do that. They can say, we're going to spend X million dollars more on program A and X million dollars less on program B. That's discretionary. However, there's an entirely different part of the budget that is for another type of spending called mandatory spending. Mandatory spending is for entitlement programs. An entitlement program is a program where the recipients are legally entitled to benefits. So in the law, it spells out that if you meet these criteria, you are then legally entitled to get these benefits. So an example could be Social Security. If Congress wants to spend less money on Social Security, it has to go through what's called the authorization process because Social Security is considered mandatory spending. If you want to spend less on Social Security, you are going to have to change the eligibility requirements. So you may want to raise the retirement age to 72. When you do that, you make less people eligible. The fewer people who are eligible, the less benefits you'll pay, the less money you'll be spending in Social Security. So that's mandatory spending. It goes through an authorization process, going through authorization committees. Discretionary spending goes through the appropriation process through appropriations committees. But the formulation phase is supposed to be done no later than September 30th. It never gets done by September 30th. Typically, what Congress will do is they might be able to pass one or two or three appropriation bills, but they'll have a whole bunch of appropriation bills that they haven't finished yet by September 30th. So, whenever that happens, we move to the new fiscal year on October 1st, then those areas of spending do not have legal authorization to spend money. So instead, what Congress will do is for all those areas where the appropriation bill has not yet been approved, they will pass what are called continuing resolutions or CRs. So, for instance, Department of Homeland Security. They could not come to an agreement on Department of Homeland Security appropriation bill. So what they did is they passed a continuing resolution. These continuing resolutions will fund the department at 80% of the level it was funded last year for a temporary period of time. The last continuing resolution for Department of Homeland Security was a 2-week continuing resolution. Those 2 weeks expired. And when those 2 weeks expired, we are now operating under a partial government shutdown for the Department of Homeland Security. It is the only appropriation bill that has not yet been passed by Congress and signed by the president. When we have a situation where we have a bunch of different areas that have not had their appropriation bills passed and our continuing resolutions have expired, then Congress has two choices. One choice is a government shutdown or a partial government shutdown. And the other choice is then to take all those unpassed appropriation bills and cobble them all together into this monster piece of legislation that is called an Omnibus Budget Reconciliation Act, otherwise known as an OBR. Let's call them OBRs. But it's an Omnibus Budget Reconciliation Act. So we take everything that hasn't been passed, we squish it all together, and we pass an OBR. Typically, the way budgets are done is that they're done through OBRs. And so all those unpassed bills get put into an OBRA and all passed at the same time. That leads to us passing these mammoth pieces of legislation where we overspend and where we don't know what's in that legislation, sometimes until 2 or 3 weeks after we have passed it. It is a short way to say it, it's no way to do a budget. But that's the way the federal government usually operates in terms of budgeting. Here in California, the formulation phase runs from January until June 15th. And the state legislature is required to pass a budget no later than June 15th. But we have this little quirk in the process in California known as the May revise. So in the middle of May, we will get this May revise, which will be a revision of the amount of money that we are generating. So back in January, the Legislative Analyst's Office, the Department of Finance, will forecast here's the amount of money we're going to generate from the state income tax and from the state sales tax. Then when we get to the middle of May, we actually have receipts. We've actually collected the income and the sales taxes. So now we can actually know how much money we have generated. If the amount we have generated, our receipts, are greater than our forecast, then that May revise may call for spending more money in the budget. If our receipts are running behind our forecast, that's when we're going to have cuts in the governor's budget as a result of that May revise. So the governor revises their budget in the middle of May. That revision then goes back to the state legislature to be passed no later than June 15th, signed by the governor by June 30th for the beginning of California's fiscal year, which is on July the 1st. Once the fiscal year begins, October 1st at the national level, July 1st here in California, we then move from formulation to our third phase, which is execution. This is the actual spending of the money in that given fiscal year. So execution will then run from October 1st to the following September 30th, or in California from July 1st to the following June 30th. Once we are done spending the money, then we move into the fourth phase, which is called evaluation. And that's where we go back and we evaluate the books. We do our audits to see, did we spend the money in the legally appropriated way we were supposed to? And then do performance and management audits to ask the question, how well did we spend the money? Did spending the money on these programs help us achieve the goals that we are trying to achieve? And not to complicate the process more, but here in California, there's also a little thing known as trailer bills. This is something somewhat unique to California. So, whenever the budget is passed on June 15th, signed by the governor by June 30th, the new fiscal year goes into effect on July 1st. But the budget process is not yet over because the state legislature will then go back and pass this legislation known as trailer bills. They're called trailer bills because they are bills that trail behind the passage of the budget. A lot of these trailer bills will then lay out the specifics of how money will be spent. So a lot of local governments, when they hit July 1st, I know my district was like this, we were hesitant to go out there and start spending money until the trailer bills had been passed. Because until we see what's in those trailer bills, we really don't know all the specifics of how we are allowed to spend that money. So we'll wait until those trailer bills come out, and then based on those trailer bills, then we'll start spending the money throughout July and beginning of August. So that's again a kind of a little unique twist that we have here in the state of California. So the federal budget process is broken. We very rarely get budgets done on time, and we never have surpluses. We are always running a deficit. The federal level, we have run a deficit every single year since 1969, with the exception of 2 years. Otherwise, we run a deficit every single year. Here in California, our budget process is not nearly as broken in that we tend to get our budgets done on time. We get our budgets done on time because of two reasons. One reason is we have one party supermajorities in the Assembly as well as the Senate and the governors of the same party. When you have that type of one party control, it's much easier to get a budget done. The second reason is because we now only need a simple majority to get a budget passed through the state legislature. Historically, we needed a two-thirds majority, which was very difficult to get. Now we only need a simple majority, so we almost always have our budget done by June 15th. So in that respect, the California process is in much better control than what we see at the national level. So what do budgets look like? And this is something that will be handy for you on the final assessment. Also, this is something that you'll be covering prominently in 555. Budgets can take on different types of formats and can look different from each other. The four main budget formats that we cover here in this class are line item, performance-based, program-based, and zero-based budgets. Now, because we are a survey-oriented class, we don't have the time to get into examples of these. You will get into examples of these in 555, but just kind of from an interpretation perspective, the first type of budget format is a line item. Sometimes line item budgets are referred to as object of expenditure budgets. In a line item object of expenditure budget, the budget will be organized around line items. So here's the amount of money we're spending on salaries. Here's the amount of money that we are spending on benefits. Here's the amount of money that we are spending on supplies. Here's the amount that we are spending on maintenance, and so on and so on. So all the information you get from a line item budget is how much money you're spending and what you're spending that money on. One of the classics articles that was assigned for this class was the Alan Schick article. In an Alan Schick's article, he makes the argument that there are three main purposes that a budget can be used for. He says the first purpose we use a budget for is for the purpose of control, to control the amount of money we're spending and then control what we are spending that money on. A line item budget is a perfect type of budget for the purpose of control because that's all the information you get. How much you're spending and what you're spending that money on. We see line item budgeting used primarily at the local level of government. The vast majority of governments here in Southern California at the local level will use line item budgets. They're very easy to put together. The problem with the line item budget is you don't get a whole lot of information. All you get is what you're spending how much you're spending and what you're spending it on. That's all the information you get from a line item budget. A second type of budget format is a performance-based budget. Schick tells us that a performance-based budget can be used by an organization for the purpose of management, to help the organization better manage how it is spending its money. In a performance-based budget, you will take a simple line item budget and then you'll add in performance indicators to show you how well you are spending the money. So a quick example would be a police department. So that police department will have X amount of money that it will spend on police patrols. So here's the number of hours of police patrols that will be funded with this line item. Then a performance-based budget will go beyond that and ask the question, well, so what? If we're spending this amount of money on this number of patrol hours, what do we get for those patrol hours? So a performance indicator could be if we patrol 8,000 hours per year, I'm just making these numbers up, then we will have a 10% reduction in property-related crimes. We may have a 20% reduction in violent crimes. Those are the performance indicators of how well we are spending that money. So to look at another way, a line item budget tells us how we're spending the money. A performance-based budget tells us how well we are spending that money. And so by having those performance indicators, it allows us the information we need to better manage the operations of our organization. Now, it's very common for governments when they do performance-based budgeting to combine performance and line item budgeting. So they'll have a basic line item budget and then they'll build performance indicators into that budget. When you see a type of budget being used at the local government level in Southern California, other than a line item, it's going to probably be a performance in that they're going to incorporate some of those performance indicators. So that's your second type of budget. Very good for helping you manage how you're spending the money within your organization. Then Schick tells us the third purpose of a budget format is the planning purpose. To use the budget document for the purpose of strategically planning our activities as an organization. So a program-based budget will allow us to see how all the different activities that we are funding are contributing to the achievement of programmatic goals. Now, a program-based budget is going to look a lot different than a line item or a performance-based budget. Line item and performance-based budgets are all oriented around units and departments and divisions. So you'll have a police department budget and a fire department budget. In a program-based budget, rather than being organized around the department, the budget will be organized around the program. So think of examples such as protection of persons and property. That is a program. That program may be contributed to by the police department. It may also be contributed to by activities funded in the fire department. All those activities, irrespective of which department they occur in, that contribute to the protection of persons and property, all those functions and activities will be budgeted together under that heading of the program protection of persons and property. So the budget is organized according to programs rather than departments and divisions. Program-based budgeting is something that takes a lot more time to do. It's going to require a strategic planning process because you're going to have to understand how all the different activities you engage in, which programmatic goals they are intended to try and achieve. So it's going to take a lot of strategic planning. For that reason, program-based budgets are typically not used very often at the local level. Where we see program-based budgets used will primarily be at the state level and sometimes at the federal level as well. The Department of Defense, since the 1960s, has used some variation of program-based budgeting. So that's our third budget format when you want to plan the operations of your organization. And then the fourth budget format is called a zero-based budget. This is also oriented around planning. A zero-based budget will require that we go back and re-justify why we are spending money on a certain type of expenditure. So rather than just assuming we spent money on it last year, so we'll spend money on it again this year, like you would in a line on a budget, this requires you to go back and re-justify spending money on this expenditure. The way zero-based budgeting works is it's kind of a bottom-up budgeting process where you start at the lowest levels of your organization. Each one of those lower levels of your organization are called units. And then each unit will put together what are called decision packages. Each decision package will then lay out different ideas for spending and then the consequences of spending money in that way. So, real quick example, you've got a countywide library, and that library has a bookmobile program. So, what you may do is you may put together a series of decision packages for that bookmobile. So, one alternative would be to fund it at exactly what we funded it at last year. We'll then ask, well, what are the consequences of that? Well, the consequences will probably be able to serve about the same number of patrons that we served last year, maybe a few less because of increases in inflationary factors. We'll probably be able to serve about as many patrons as we served last year. But then the question becomes, what if we increase the budget by 5%? Well, if we increase the budget by 5%, we'll be able to serve X number more patrons. We'll be able to increase our circulation rates by maybe 10%. Those are the consequences of spending 5% more. What are the consequences of spending 5% less? And you compare all these different alternatives and you put all these alternatives into what are called decision packages. You then rank and prioritize those decision packages, and the highest ranked decision packages then become your budget. The big thing to remember with zero-based budgeting is that it's a very rigorous process. It creates a mountain of paperwork, and it takes a whole lot of time and effort. So much so that we almost never, there are some very small exceptions, but we almost never see zero-based budgeting used at the local level. Where we see zero-based budgeting used is at the state level. There are states like Georgia and Virginia who use a modified approach to zero-based budgeting. Their approaches will say, for instance, we will take 20% of the state's budget each year and we will budget it in a zero-based budgeting process. Then the next year we'll take a different 20%. Then the next year a different 20%. And so on and so on. So after a 5-year period of time, every part of the state budget has been subjected to a zero-based budgeting process. Again, it's really good in terms of rationality. It's also really good in terms of just kind of helping us plan the operations of our organization. Any questions on these different budget formats and what they are and how they work? Everybody still with me?
Yes, we're still with you, and I have no questions.
I appreciate that. I just thought my camera had frozen. And so I thought, oh my gosh, I've talked for 15 minutes and I'm no longer in the classroom. So I'm good. Thank you. Just want to
Yeah,
make
no,
sure that I'm still here. All
you
right.
disappeared, but we heard you. We were hearing you.
Okay. Thank you very much. Yeah, just for some reason, my camera just decided to shut off. And I'll take that. If there's no camera, that's much better than at least I'm still in the classroom. So these are the budget formats you'll be thinking about then on your final assessment. And what you'll be doing is based on that scenario, you'll be thinking about what budget format you think would work and why that budget format would be appropriate. You'll get into a lot more detail on these budget formats in 555. In 555, you'll have the opportunity to put a budget together. Whenever I would teach 555, we would do a line item and performance-based budget, but it really depends on who your instructor is for 555, which budget format you'll then be creating as your post-instructional assignment. But at least gives you some insight in what these formats are before you get to 555. Up to this point in time, we have talked primarily about the expenditure side of the budget. Now let's talk about the input side, the revenue, because in order to spend money, we have to have money to spend. So we know that governments, they derive their revenue from a variety of different sources. Some sources are based upon taxation. Some sources are non-tax sources of revenue. So let's very quickly just kind of go through what they are and their advantages and disadvantages. In terms of tax-based sources of revenue, The big three are obviously property, income, and sales taxes. Property and income taxes are what we consider to be ability to pay taxes because people pay taxes based upon their perceived ability to pay those taxes. In the property tax, your ability to pay is based upon the value of your home, the assessed value of your home. Your income taxes, your ability to pay is your adjusted gross income. So they're both ability to pay. The third type of tax is a sales or consumption based tax. Sales taxes are based upon a benefits received principle, in that you pay the tax based upon the amount of benefit that you get from consuming some type of a good or some type of a commodity. Of the three, the most progressive type of tax tends to be the income tax. And there's a difference between progressive and regressive taxes. A progressive tax is a tax where people with more of an ability to pay a higher amount in taxation than those with less of an ability to pay. In terms of a regressive tax, those who have more of an ability to pay less. And so progressive tax, people who have more of an ability to pay more in taxes. In regressive tax, those with more of an ability to pay less in taxes. So we hope to make our taxes as progressive as possible. The marginal graduated income tax brackets that we use in our income tax at the federal and the state level are designed to try and make the income tax progressive. We know that we have a ton of loopholes in income tax code. Loopholes so big that you can drive a semi truck through. And so that's why we have situations where we have billionaires who pay 0% effective income tax rates and middle Americans who are paying 22 to 24% income tax rates. So even though we try and make it as progressive as possible, we know those tax loopholes kind of harm the progressive nature of it. But it is much more progressive than a property or a sales tax. Property taxes here in California are governed by Proposition 13. And what Proposition 13 has done is Proposition 13 has limited the amount of property tax revenue that local governments can generate. So now local governments, because they can't generate a lot of money from the property tax, they have to start looking at other forms of either taxation or non-tax sources of revenue. Local governments here in California don't have access to the income tax. They do have access to a local option sales tax, but we know that sales taxes are also very closely tied to the economy. So in poor economic times, sales tax revenue is going to go down. With sales taxes, you have general sales taxes with a tax rate that applies to the broad amount of commodities that are transacted. With selective excise taxes, those are selective sales taxes that apply differently to different types of transactions. So a yacht tax would be a luxury type of selective excise tax. A gas tax is a selective excise benefit-based types of tax. A sin tax is a tax on tobacco or alcohol or cannabis. That type of sin tax is, again, a selective excise tax because it applies differently to those different types of commodities. Since local governments under Prop 13 have been very limited in the amount of property tax revenue they can generate, they have really turned their attention more toward non-tax revenue sources. Two different types of non-tax revenue sources are user charges and user fees. User charges are charges that are linked to the consumption of some type of, usually a service. So you think about something like utilities. So you pay a user charge on the amount of utilities that you are consuming. That's a user charge. User fees are usually not tied to the amount of anything that you are consuming, but rather they are tied to the issuance of licenses. So you want to get a driver's license, you have to pay a driver's license fee. You want to drive your car on the road, you have to register it and pay a registration fee. You want to open up a business in a jurisdiction, you have to get a franchise license and pay a franchise fee. So what we have seen statewide is that local governments, after Proposition 13 in 1978, have really moved away from property taxes and moved more toward these non-tax sources of revenue. Here in Southern California, a lot of local cities are still pretty closely tied to their property taxes. And so local governments in Southern California, their revenue diversity looks a lot different than what we see up in Northern California. But as a whole, statewide, as an average, we have seen a lot of local governments move more toward non-tax as opposed to tax-based sources of revenue. But our goal in budgeting is that we will balance our revenues and expenditures. And indeed, the state constitution requires that local governments balance their revenues and expenditures. If in one given year your expenditures exceed your revenues, you then have what is called a deficit. So the definition of a deficit is an imbalance in revenues and expenditures in a given fiscal year. That's what a deficit is. Now, since local governments are required to not deficit spend and they're required to at least balance their budgets, they have gotten relatively creative in finding ways to balance their budgets, at least on paper. One of the ways in which they can balance their budgets is by issuing what is called short-term debt. Short-term debt is usually referred to by the term notes. So if you're a local government and you're coming up on the end of your fiscal year and you don't have enough revenue to cover your expenditures, you may issue a short-term note. You may borrow money for a short period of time in order to try and give the appearance of not having a deficit. So, for example, your fiscal year ends on June 30th. You're looking at your books and you're not going to be able to, at least on paper, cover your expenditures. So what you will do is you'll go out there and borrow money. You will issue maybe what's called a revenue anticipation note, and you will secure the repayment of that debt with the revenue that is coming in for the next fiscal year. So you're kind of playing catch up every year. And so whenever that revenue comes in the next fiscal year, then you will pay off that debt with that revenue when it comes in the next fiscal year. It allows local governments to avoid having the appearance of a deficit in a given fiscal year because the state constitution precludes them from having a deficit. So short-term borrowing is going to be borrowing in the form of notes that has a maturity date of less than 1 year in duration. Any debt that matures in less than 1 year, that comes due in less than 1 year, that is considered to be short-term debt. Anything that matures in more than 1 year is considered to be long-term debt. And that is what we are most interested in for the scenario on the final exam. So let's assessment. So let's talk a little bit more about long-term debt. Long-term debt that matures in more than 1 year is referred to as a bond. So whenever a government wants to go out there and make renovations to its aquatic center or build a new recreation center, that's going to be a very expensive endeavor. So they may not have the money on hand in order to do that. So they'll go out there and borrow money. When they borrow money, they issue bonds. Those bonds are then purchased by investors. And when investors purchase those bonds, the proceeds paid by the investors, that's the money that's then used to construct the capital project. Then the city will repay these investors over a number of years. So maybe you'll have a 20 or 30-year maturity date on these bonds, and then you'll make principal and interest payments back to these investors over that 30-year period of time until that debt has been repaid. So that's what's referred to as a bond. Bonds are used to generate enough money to complete a capital project when you don't have the money on hand to do so. And raising, say, $100 million in 1 year through tax increases would be cost prohibitive for your residents. And so, therefore, the tax increases are much smaller because you're just paying it back over a 30-year period of time. It's like going out there and buying a $50,000 car and not having $50,000 up front to pay for it. So instead, you get a loan on that car. It's the same general idea. Another reason why we issue bonds when we do long-term debt is for the purpose of what is known as intergenerational equity. And text intergenerational equity. So say, for instance, you're building a recreation center future generations are going to be using that recreation center. So is it fair for people who live in the city in year one to bear the entire burden of the cost of the construction of that recreation center? Or is it more fair to spread that pain out over 30 years so that future generations who are using that recreation center will also then have to pay for it through repaying that debt? So intergenerational equity also argues for the issuance of long-term debt. So long-term debt comes in the form of bonds. There are three main bonds that we cover in this class. The first one is what's called a general obligation bond, sometimes referred to simply as a GO bond. A general obligation bond is a basic type of long-term borrowing where the government will borrow money, investors will purchase those bonds, and the government promises those investors that it will use what's called its full faith and credit to repay the debt. So the government says, we're going to borrow this money. We will repay you, and we promise we'll use our full faith and credit. We will use every resource at our disposal to make sure you get your investment back. So if we need to lay off employees to save on salary, we will do that. If we need to cut other programs, we will do that. If we need to put off other capital expenditures, we will do that. We will do anything we have to at our disposal to make sure you get your money back. That makes a general obligation bond a very safe investment for investors. You know you're going to get your money back. We know whenever people invest their money, there is this relationship between risk and reward. The higher the risk, the more reward, the more return they're going to expect. The lower the risk, the lower the reward. This is a very low risk type of investment, which means that investors are not going to expect a high interest rate. So the nice thing about general obligation debt is that governments pay a low interest rate. It's a much cheaper way to borrow money than other types of bonds that are available for you to use. So that's the big advantage of a general obligation bond. The disadvantage is that you are guaranteeing your full faith and credit. So you're kind of opening yourself up that you're guaranteeing you will repay this debt no matter what. Another problem with general obligation bonds is that states will impose limitations on the amount of general obligation bonds that cities can issue. So oftentimes what they will do is they will put a limitation such as you can only issue the value of general obligation bonds up to 2% of your total property tax capacity, the assessed value of all property in your city. That's your limitation. So sometimes they're subject to those limitations. Another potential problem is that they're oftentimes also subject to voter approval. So you have to go out to the voters and have the voters approve these general obligation bonds, which makes sense because the city is pledging its full faith and credit. And so this is a very heavy type of investment or a very heavy type of borrowing. And so people need to be able to participate in deciding whether or not they approve of issuing these general obligation bonds. And oftentimes, the voter approval that you need is a two-thirds majority, which is extremely difficult to get. It was so difficult to get a two-thirds voter approval that the state several years ago passed Proposition 39. And Proposition 39 allowed school districts to issue general obligation debt with only 55% voter approval because schools just could not get a two-thirds voter approval, so that lowers the threshold down to 55%. However, if you are going to pass a general obligation bond under Prop 39, yes, you have a lower voter threshold, but then you also have to establish a citizen oversight committee. And that citizen oversight committee will then audit every single dollar that is being spent of those general obligation proceeds. So that's a traditional type of debt known as a general obligation bond. A second alternative is what is called a revenue bond. A revenue bond is different in that the repayment on the revenue bond is secured from the revenue that is generated from operating the facility. So you're going to use this money to create a recreation center. Then you're going to charge membership dues for people to use the recreation center. That gives you a stream of revenue. You then capture that stream of revenue and you use it to make your principal and interest payments to retire the debt. The nice thing about a revenue bond is that you are not guaranteeing your full faith and credit. So if this recreation center doesn't work out and it goes belly up, then you don't have to repay the debt and the investors end up losing their investment. Obviously, that's a very high risk proposition for an investor. And we know that risk reward type of relationship, the higher the risk, the more return that investor is going to anticipate. So revenue bonds come with much higher interest rates than general obligation bonds. So they're going to be much more expensive for governments to issue. Also, since the revenue bond is being repaid from revenue from the recreation center, that recreation center must not only generate enough revenue to repay the debt, make those principal and interest payments, but also must generate enough revenue to cover its operating costs. Because if it can't cover its operating costs, then obviously it's going out of business and then you default on the debt. So you need to make sure there is more than adequate revenue in order to repay the debt. Investors, because this is a very risky investment, will probably require that the bond have what are called covenants built into it. And those covenants will then be requirements on the city to reassure the investor that they will get their money back. So maybe an operation covenant where the city will say this recreation center will be open from this time to this time. The membership dues will be this amount. And our surveys have shown that this number of people will be using the recreation center. Those are promises that you'll have to make in your revenue bond to reassure the investors so they're willing to invest their money into a revenue bond. Also, revenue bonds, the interest earned on a revenue bond may not be tax exempt for investors. One of the big selling points of government bonds is that the interest earned by investors is exempt from federal income taxes. So they can write that interest off of their taxes and don't have to pay taxes on it. That is true for general obligation bonds. It may not always be true for revenue bonds. So revenue bonds may not be tax exempt. And if they're not tax exempt, then you end up losing a lot of the selling point, if you will, behind those revenue bonds. So those are revenue bonds. There are advantages, there are disadvantages. They're much more expensive, but you don't pledge your full faith and credit. Then a third type of bond that's available is a double barrel bond. In a double barrel bond, you are combining the best of both worlds. So you're going to say a percentage of this bond will be general obligation in nature, and a percentage of this bond will be revenue in nature. So part of it's general obligation, part of it is revenue. Since part is general obligation and part is revenue, the interest rate for a double barrel bond will fall somewhere in between the low interest rate for a general obligation bond and the higher interest rate for a revenue bond. So it's kind of a combination of the two, almost like a mixed scanning type of approach to issuing debt. So those are three different types of bonds that governments can issue. There are a lot of other bonds available that you'll talk about in 555. Capital appreciation bonds, zero coupon bonds, lease rental bonds, sale leaseback bonds. Local governments have gotten very, very creative in their ability to design these bonds to try and get around a lot of state limitations in order to give them more flexibility in how they borrow money. It's very important for governments, regardless of the type of bond that they are issuing, to be very careful at protecting their credit rating. Because what will happen is whenever you are ready to issue a bond, you have to go to a credit rating agency such as Standard & Poor's or Moody's or Fitch's. And those credit rating agencies will then review your credit worthiness and will then issue a bond rating, a credit rating to your bond. The better your credit rating, the lower the interest rate you will have to repay. The lower your credit rating, the higher the interest rate, kind of similar to in our personal private financial lives. So it's important for governments to get a good bond rating to save them money as they go out there and they borrow this money. But these long-term bonds typically are used to pay for those capital projects because those capital projects are very expensive. They last for a very long time and they do not recur year after year. Hopefully, this recreation center will be there for the next 50 or 60 years. So it's a non-recurring type of expense. So to kind of wrap all this up, I know we don't have a whole lot of time left. I think we have kind of established that the federal budgeting process is out of control. We never get budgets done on time, and we never get budgets done that are balanced. So Congress has been struggling with the out of control federal budgeting process for many, many years, literally for decades. What you see on the screen are three different attempts that Congress has made to try and get the federal budgeting process under control. We're not going to go into the specifics on these, but just to kind of give you in broad parameters, in the 1970s, Congress had run about 6 years of budget deficits. So they wanted to get out of deficit spending. Congress also felt that the budgeting process was chaotic and very much tilted toward the president, in that the president had a lot more tools at his disposal than Congress did. So Congress passes this thing called the Budget and Impoundment Control Act. Budget and Impoundment Control Act focused on the budget process. If we could change the process, we could hopefully get the budget process under control. So it did a lot of things. We won't get into all of them, but some of the major things that it did is it tried to limit the president's power over the budgeting process through limiting the president's ability to engage in what were called impoundments. An impoundment is when a president will sign an appropriation bill and then decide not to spend the money. That's called impounding those funds. They may impound those funds on a deferral basis where they say, I'm just not going to spend the money right now. I'll release the funds in the future. Maybe I'm going to release them when we get federal income tax revenue coming in. I'm just going to release them later to try and sync them up with the revenue generation schedule. That's a deferral. And they end up spending the money in the end run. The other type of impoundment is what's called a rescission. And that's what's important for us here today, because the Trump administration has engaged in two different rescissions. One rescission they engaged in, they rescinded the funding from appropriation bill where the president said, I disagree with this program or these programs, and I am not going to spend money on these programs. He then put together what was called a rescissions package, a list of all this rescinded funding, and then sent it to Congress. Congress reviewed it and Congress approved it. That's the way the process is supposed to work. If you're going to rescind funds and refuse to spend money, you need to get the approval of Congress. The second time President Trump entered into rescissions, he did not send a rescissions package to Congress. He didn't contact Congress at all, and Congress didn't complain. And so those funds just didn't get spent. The Budget Impoundment Control Act wasn't used, and Congress didn't complain about it. So only if Congress stands up and says rescissions, refusing to spend this money violates federal law, will they be able to push back on Congress? But that was an attempt to try and give Congress more control over the budgeting process. It didn't work. After the Budget Impoundment Control Act was passed, we still ran deficits year after year after year, and we still were not getting the budget done on time. So in the 1980s, Congress tries again. And this time they focus on the budget deficit itself. So through this law called Graham-Rudman-Hollings, and those are the three people on the screen there, they establish maximum allowable deficits in each year and put together a timetable so that every year the maximum allowable deficit would go down. Suffice to say, it did not work because Congress has the ability to go back and change those timetables and change those deficit targets. So in a given year, if they weren't hitting their deficit target, they just went back and they modified it upward. And instead of deficits going down, deficits ended up going up. So that failed as well. So in the 1990s, they tried again. And this time they tried with a Budget Enforcement Act. The Budget Enforcement Act focused on spending as opposed to deficits. When the Budget Enforcement Act focused on spending, it said, let's create different categories of spending: defense, domestic, and international. And then we'll create walls between those different areas of spending so that you cannot cross over from one to the other. So if you want to spend more money on defense, you can't take money away from domestic. And it also created this very novel concept that I'm sure none of us have ever heard of before, which is you pay for things as you go, otherwise known as pay-go. This is how we usually live our daily lives, is we pay for things as we go. We pay for things with money that we have earned. Pay-go told Congress, if you want to spend money on a new program, you're going to have to pay for it by spending less on another program. You cannot pay for it by borrowing money. So it was meant to try and limit Congress's ability to borrow money. This act, along with a couple of other balanced budget acts in the 1990s, along with the dot-com boom in the 1990s, where the internet exploded, and you had all these Silicon Valley companies that were generating money hand over fist, that generated a lot of federal income tax revenue. You basically had a situation where you had this huge influx of revenue at the same time that you had limitations being placed upon spending. And lo and behold, when you generate more revenue and you spend less money, what happens? You eliminate a deficit. And in 1999 and 2000, the very end of the Clinton-Gore administration, we had 2 years where we had no deficit spending. And President Clinton had a very big press conference where he had a whiteboard and he wrote a big zero on the whiteboard and said, we finally do not have a deficit for the first time in 30 years. Then along came the terrorist attacks on September 11th, and then we went right back into deficit spending with the wars in Iraq and Afghanistan, and the deficits have continued to balloon pretty much, not every year, but pretty much each year after that. So despite all these attempts, the moral of the story is you can change the process as much as you want. But in order to get the federal budgeting process under control, to avoid deficits and get budgets done on time, it's not a matter of procedural changes. It is a matter of political willpower. You have to have members of Congress and a president who are willing to make those tough political decisions of generating more revenue and spending less money in order to get away from deficits. We've seen in recent years on the part of both parties that political willpower just does not seem to be there. So to wrap it all up, what does this mean for the future of public budgeting? The future of public budgeting at the federal level is relatively bleak in that we are going to see deficits year after year for the foreseeable future. Those deficits are going to continue to increase, especially as we have more and more military engagements. So chances are we're going to continue with deficit spending. If the past few years have been any prologue, there is very little likelihood we're going to start magically getting budgets done on time. I think we're going to continue with continuing resolutions and partial government shutdowns. So the federal picture is not great. But to make you feel better, Diego, the state picture is a little bit better. And at least here in the state of California, we do tend to get budgets done on time. We do tend to be able to, for the most part, be able to come close to, at least on paper, balancing our budgets. The May revise that's coming up this May is actually looking pretty good. And the word out of the Legislative Analyst's Office and the Department of Finance, especially the Department of Finance, is that income and sales tax receipts are actually running ahead of the forecast that were projected back in January. So we're actually going to have more revenue than we thought we were going to have once we get to the May revise. So that's always a much happier decision to make. Do you want to spend more money? Do you want to put that money into a rainy day fund? Those are always much more pleasant decisions than what do we have to cut and who's going to lose their benefits. So at least the future budgeting picture looks better at the state level than it does at the national level. That kind of wraps up this discussion of public budgeting and finance to again get you ready for PPA 555, where you'll get into a lot of the more granular details on all these different budget formats and different types of revenue. But at least this kind of whets your appetite for some of those things you'll cover then in public budgeting. This then covers all the information we cover in this course. It also provides you with all the information that you need to do an excellent job on the final assessment. As you work on that final assessment between now and next Thursday, Any questions at all that you have, send me an email. I'm happy to answer any of those questions. I'm sure everyone will do just as well as the final as everyone did on the midterm. It's been a pleasure working with everyone. I'll get this video up on our website no later than tomorrow morning. And I really hope to work with you in future courses. Best of luck throughout the rest of the program. And I hope everyone has a great remainder of the week and a great weekend. Been great working with everyone. Take care.
Buenas noches. Thank you. Adiós.
Thank you. Thank you very much.